Hi there, good morning. I'm Lake Martin. I'm the Executive Director of the Nevada Cannabis Association, and thank you so much for joining us today for today's webinar, Select Issues in Department of Taxation Administration of the Wholesale Marijuana Tax. Today's presentation will be given by Attorney Paul Larsen of Black and Wadhams in Las Vegas. He's an administrative and regulatory attorney with more than 30 years of experience in regulatory practice. He has practiced before a number of cannabis regulatory agencies in Nevada, including the Department of Taxation and the Cannabis Compliance Board. He's also obtained land use and licensing approval for cannabis operations in Clark, Esmeralda, and Douglas counties and Carson City. He's the person I go to when I have a tax question because he's great at telling you not only what the law is currently, but he has a great mind for tax policy as well, which is what's going to make today's program so interesting. During today's webinar, Paul will discuss October 2025 Nevada Department of Taxation guidance memo advising Nevada's cannabis industry on the application of the Nevada Wholesale Marijuana Tax on transactions occurring on sovereign Native American tribal lands, as well as issues related to the memo, DOT's use of METRC in WMT audits, the Administrative Procedure Act, and a review of the impact of failing to file and pay WMT and sales taxes in a timely manner. So with that, welcome, Paul. Thank you so much for joining us today to share your insight.
Thank you very much. I just wanted to preface my remarks this morning by pointing out that we're talking about select issues with the wholesale marijuana tax, which basically means there are a couple of things I want to complain about, and it's not going to be a comprehensive dive into the WMT, but it will be mostly how the WMT is affected by the Department of Taxation's use of the Administrative Procedure Act or lack of use of the Administrative Procedure Act is probably a better way to describe it. And there's my self-promotion slide. Our agenda, as I said before, wholesale marijuana tax is the primary thing we're talking about, but from my perspective, you can't talk about the WMT without also talking about the Administrative Procedure Act, because that is basically the vehicle for the Department of Taxation to extrapolate and expand upon the authority they're given under the WMT for the purposes of administrating the WMT. So as I said before, I'll be talking about select issues and then some final tips and takeaways. So with that, we'll jump right into it. The WMT is codified at NRS 372A 290. It currently reads that there are two ways that the tax is administered, which is basically 15% of the sales price. The sales price is determined by a willing buyer, willing seller in the marketplace. If it is not an arm's length transaction, if it's a transaction in a vertical transaction, then the fair market value at wholesale of the cannabis is used. And I'll be referring to the fair market value as FMV. Those of you familiar with the WMT and FMV will recall that prior to the amendment of the statute in 2023, that the statute simply read that the WMT was 15% of the sales price of wholesale sale of cannabis, and that the Department of Taxation was charged with determining whether that was a fair market value. My partner, Jim Wadhams, and I have taken the position in a number of cases that fair market value was not a delegation of authority to the Department of Taxation to calculate fair market value and impose that calculation. I refer to it as a fictional value upon the industry, but that's exactly what happened. And before I get into that in any depth, I want to show you NRS 233B 038. That's the Nevada Administrative Procedure Act. And this particular definition is the definition of regulation, which is important for the purposes of talking about issues that I want to go through for the rest of this discussion. And that's basically that any time an agency adopts a rule, standard, directive, or statement of general applicability, which effectuates and interprets law policy, that is considered a regulation. So if you see a standard, a directive, an interpretation of statutory law that the agency intends to apply uniformly, that is by definition a regulation. And the agency is charged by the Administrative Procedure Act with taking certain steps for the enactment of that regulation, that standard of general applicability. And I'll be using that term today because regulation, it's a defined term here, but you'll know from this preface that when I use the term standard of general applicability, you'll know that I'm referring to a regulation as defined by the Administrative Procedure Act, and by meeting the definition of regulation, a standard of general applicability has to be adopted by the standards set forth in the Administrative Procedure Act. And that is a notice of intent to adopt a regulation given to the public, a circulation of a proposed regulation, actual ability of the public to have notice and comment, usually by submitting written comments or appearing at a workshop or hearing where they submit oral testimony regarding the proposed regulation. And then the formal adoption of the regulation, which then gets referred to the Legislative Counsel Bureau for review for possible revision if it conflicts with the law, or the Legislative Counsel Bureau determines that regulation requires clarification. And then it's referred back to the agency for formal adoption. So it is quite a cumbersome process, and intentionally so that every standard of general applicability is properly vetted through a public process rather than just adopted by fiat of the agency. So let's jump right into the administrative procedure, into the WMT. On the right-hand side of this slide, you can see the WMT form promulgated by the Department of Taxation. This one is from, I believe, the first quarter of 2019. And on the right, on the left, you have the current WMT form promulgated by the Department of Taxation for the last quarter of 2025. Now you'll see significant differences in these two forms. Specifically, if you look at the form from 2019, you'll see that the form is simply you enter the amount in terms of pounds of the product classification sold times a fair market value that is calculated by the Department of Taxation, and then you get a total. Simple math. The only variable you have input into on this form is the weight of the product sold. You don't determine what the fair market value is. In many cases, you don't even have the opportunity to designate what the product classification is. There are 9 classifications there, and you have to use one of the 9. So, and included in this form, and it's an issue I'll be talking about, is number 7, was pre-rolled cannabis cigarettes. And in that instance, you'll notice that it does not use pounds as the unit of measurement that is multiplied by the fair market value. Instead, it was at that time individual joints or cigarettes, or the industry nomenclature right now is it's everybody refers to them as pre-rolls. And those were taxed at a specific value of $5 per unit. You compare the form on the left, which is the current tax form, and you have options. You have, if we go to category one, you have affiliate sales. And as I showed you in the first slide regarding the WMP, WMT, you have the total weight of product transferred times the fair market value is calculated by the Department of Taxation. For non-affiliated sales, otherwise not arm's length transactions, there is no FMV that kicks in. It is simply 15% of whatever the sales price was. And you basically look at your sales records and whatever you sold it for in an arm's length transaction, it's 15%. Simple, easy peasy. If you go down to pre-rolls, item number 6, you'll notice that there's now being taxed by the amount sold in pounds. Compare that to the form from 2019, and you see it was the Department of Taxation was looking at it as the amount sold by the number of units. So that's a particularly interesting issue because the statute says 15% of the sales price, doesn't say how that is to be measured, does not say measure it by the number of units, and specifically did not say that the Department of Taxation has authority to calculate what fair market value was. Instead, the statutes, the related statutes regarding taxation basically said sales price is what the product was sold for in the marketplace in an arm's length transaction between a willing buyer and a willing seller. Now, what is the reason that those forms were different? Well, there's two primary reasons for the Department of Taxation revising their form. The first reason is Assembly Bill 430 from 2023, and I think our host, Lake Martin, had a lot to do with that particular bill. And it eliminated the department's use of FMV for most arm's length transaction. It clarified for arm's length transactions that sales records rather than FMV was used for the tax. Now, what the department, from a political standpoint, AB 430 was kind of a spanking to both the Cannabis Compliance Board as well as the Department of Taxation because it was a legislative directive to the Department of Taxation to stop using a fictional value, fair market value, that in many cases was taken from a curated data set where the Department of Taxation would take a set of sales data and then determine based upon that sales data what was the average or median sales price for that particular product classification, and they designated that fair market value. And regardless of what you negotiated in the marketplace and what you sold your product for, you had to, it was valued, that transaction was valued at whatever the Department of Taxation said it was valued at, regardless of whatever you sold it for. So for example, if you sold popcorn bud at or small bud at $1,000 per pound, and you had sales records indicating that that was a negotiated price between you as the willing seller and a buyer as a willing buyer, and the marketplace transaction was for $1,000 a pound, it didn't matter because at that time the Department of Taxation had in its wisdom concluded using its curated data set that the fair market value was $1,200. And so you often paid a value that objectively in the marketplace was calculated at significantly higher than the actual arm's length transactions in the marketplace. So I don't think it's a coincidence that the Department of Taxation is currently collecting less on the WMT since the passage of AB 430. And the reason is for arm's length transaction, they're currently taxing it at 15% of whatever the market price was, as demonstrated by the sales records of the taxpayer. And previous to that, it was using this fictitious FMV value. Now they're still using the FMV value for internal transactions for vertically integrated companies. But the Department of Taxation, after their legislative spanking from AB 430, actually went and adopted a regulation reviewed by the Legislative Counsel Bureau that gave them authority through a formally adopted regulation to have a process for determining fair market value. And the statute, as indicated in my original slide, was changed so that it specifically said fair market value can be used in vertically integrated transactions, but that 15% of the actual sales price, based on the records of the company, was now being used by the Department of Taxation for arm's length transactions. And it further eliminated the use of the tax on units for pre-rolls. And that was a result of a decision rendered by an administrative law judge in a Redwood involved case that was handled by James Wadhams of this law firm. Made it very clear that the administrative law judge said the Department of Taxation had never adopted a regulation defining what a pre-roll was, had never defined or adopted a regulation indicating that they were proposing to tax pre-rolls based upon unit rather than weight, and actually construed the WMT as saying it's based on 50% of the sale value based on weight, and there is no reference to anything being priced by unit except for, I believe it's plants. So after the Redwood decision and the spanking they got from the legislature by AB 430, the Department of Taxation adjusted their approach somewhat. The lesson learned by the Department of Taxation was to specifically use the WMT formula set forth in NRS 372A 290, which says that the sales, or excuse me, the tax liability for the 15% excise tax is a simple calculation of 15% times the actual sales price as established by the records of the taxpayer times the weight sold. Eliminated the per unit tax for cannabis classifications unless they were stated in the statute. And as I said before, the only per unit classification is plants. Everything else is taxed by weight. Unfortunately, despite the fact they learned those two lessons, the department ignored their directive from the department, or excuse me, from the legislature to adhere to statutory language, and the implicit directive that if you're going to construe the WMT, you need to do it through the adoption of formal regulations. In many cases, they have not done that. So this is where we get to the place where I start complaining. So one of the more recent instances of, or a couple of the more recent instances of the department construing the WMT without actually going through the process of adopting formal regulations. In other words, construing by imposing a standard of general applicability is their position memo that they circulated in October regarding the sale of cannabis on Indian lands. I also have a case pending where the Department of Taxation has adopted a standard of general applicability for the use of metric data in doing audits of taxpayers for the wholesale marijuana tax. And a further issue is the legacy use of fair market value for vertical sales. In other words, how they're calculating fair market value under the current regulatory regime. So in October of 2025, the department issued a advisory memo regarding sale of cannabis on tribal lands. They referenced the compacts that are generally nearly identical between the state of Nevada and the various Indian tribes. And they took the position in this position memorandum that the wholesale marijuana tax applies regardless of the fact that the statute or the sale is taking place on sovereign land of the tribes. They also took the position that because the transaction was taking place on sovereign land of the tribe, that the WMT had to be applied to the tribe, or had to be collected by the tribe and paid to the tribe by the taxpayer, and that there's no payment to the Department of Taxation. Um, Interestingly enough, the memorandum seems oblivious to the fact that in many instances, the wholesale sale of cannabis on tribal land is done by the tribe as a producer or cultivator of the cannabis itself. In other words, they're acting more as a business than as a sovereign tribal government. So in that instance, the tribe would be collecting and paying the WMT to itself. um, that seems to make no sense. The memorandum doesn't address the sort of unanswered questions that are hanging out there, and that is, can the tribe waive the WMT if it's acting in a entrepreneurial capacity, and really doesn't want to take 15% of the sale price from its right hand and just simply hand it to its left hand? It does not address whether the tribe can rebate the WMT collected, and give it back to the purchaser from whom the WMT was collected. Um, the department has announced this standard of general applicability in this memorandum, but no regulations were adopted. It is a standard of general applicability because they made it very clear that it applies in every instance, but they did not vet the policy in any meaningful way. It wasn't disclosed to the public. There was not an opportunity for draft language as to implementing it. Instead, they simply issued their memorandum. And there was no opportunity for the ability to um, comment, for the public to comment publicly and provide alternative legal analysis or interpretations to the standard being promulgated by the department. In other words, this because it was a standard of general applicability, I submit that it should have been adopted formally as a regulation by the Department of Taxation, with all the procedures mandated by the department, by the Administrative Procedure Act, which would require notification of intent to adopt a regulation, circulation of a draft of that regulation, the ability of the public to review and comment upon the draft regulation, circulation of that draft regulation to the Legislative Council Bureau, and then finally, a formal announcement of the implementation of the codified regulation. None of that has happened so far. And instead, the Department of Taxation has done basically the same thing they did with, their tax returns, and that is to simply calculate or prepare it interdepartmentally and then issue it to the public. There is no public comment on these forms as they come out. There is no opportunity for the public to be heard or provide input. Each of these forms is also accompanied by instructions, and the instructions make it very clear that these are standards of general applicability to be used in every instance. Yet, despite the fact that it's standard of general applicability, in other words, a regulation as defined by the Administrative Procedure Act, these are simply adopted by fiat. However, the Department of Taxation wants to articulate these forms and the instructions for filling out the forms. There is no public comment on it. The only reason that the form on the left exists, rather than keeping the form on the right, which existed prior to AB 430, is because the Department of Taxation got a legislative spanking through the adoption of AB 430, as well as losing the Redwood case regarding taxation of pre-rolls. That takes us to the next issue, and that is the department's unilateral decision to use metric data rather than the records of the taxpayer for pre-AB 430 audits. In other words, prior to the changing of the statute, where the legislator made very clear to the Department of Taxation that in transactions that do not involve a vertically integrated business, that they had to use the sales records of the taxpayer and sales records of the purchaser and seller to determine what the price was, and it was simply 15% of that. They used their own internal rule. Now, that rule is not articulated in an audit manual. It is not articulated in a regulation. It is not articulated in any statute. But in a case I'm involved in, the Department of Taxation auditor testified that in all pre-AB 430 audits, they use metric data rather than the sales records of the taxpayer to determine what the fair market value of cannabis sold at wholesale would be. Now that's a mouthful, and what it basically means, if we go back to the example I used before, if the taxpayer logged in to METRC a batch of buds and then sold those buds, the Department of Taxation would say, well, you classified that initially in METRC as flour. Then you sold that same batch and you sold 5 pounds of it. Well, we're going to use the initial classification you did in METRC as the sales price. We're going to use our own fair market value for that classification as the basis for the taxation. So regardless of what the sales records of the taxpayer said, the Department of Taxation said, well, you classified it initially as flour. Fair market value of flour is this. So because it's flour and because the fair market value is this, we are going to tax you at a presumed fair market value of 15% of that FMV, regardless of what you sold it for. In other words, and there's actually testimony to this effect, the Department of Taxation disregarded the actual sales records, arm's length transaction sales records of the taxpayer, and simply looked to METRC. Now that's an issue because in early iterations of METRC, METRC had less than 9 product classifications. So if you took flour and initially tested it as flour and logged it into METRC and the seed to sale tracking system of METRC as flour, and later sorted that into large bud flour, small bud flour, and then sold it, it is well known that you cannot sell small buds, also referred to as popcorn buds, for the same sales price as large flour. So, but because it was originally logged into METRC as flour, it could not be, that product classification could be not be changed because METRC did not allow it in those days. You were stuck with a product classification of flour. So even though you're selling it as popcorn buds, you were being taxed by the Department of Taxation because the product classification in METRC is flour. The weight is known and the fair market value is presumed. And so you're being taxed at in that instance, the maximum value of any product classification for cannabis, rather than the nominal value that popcorn bud fetches, which is significantly less than large bud, large flower. So, and you might ask, what is the policy being served by the department's position in those pre AB 430 audits? And it's simple. Because of the limitations of METRC, a lot of product that is later sorted and sold at a lesser value, because that's what what the market will pay for it. It stays at flower. So you get a higher valued product classification, you get a higher FMV, and the Department of Taxation gets to maximize in a major way the taxable value of those products. Now, post AB 430 audits, and that is basically anything for any tax period after the amendment of the statute, the Department of Taxation is still using metric data rather than actual sales records. So, for example, if you have, and if you could see my office, you could see I've got 7,000 pages of invoices from a wholesale client where each individual transaction lists both the type of product sold and the actual product sold. And in that instance, there is the only math you do is how much did it sell for, and your tax on that is 15%. Simple. But if you're using metric data, and then they've specifically put instructions in their 2025 WMT form that in many instances, metric data is to be used rather than the actual sales records, despite the fact that the statute makes it very clear, in my opinion, that the actual sales records need to be used. A good example is the instructions in the form, that would be the form I showed you, the WMT form. Pre-rolls must be calculated on the basis of total weight of cannabis contained in each pre-roll and sold by a cultivator as recorded in the seed to sale tracking system, regardless of whether the pre-roll is made by the cultivator or a subsequent cannabis establishment. So in other words, if you have a discrepancy between metric and the tax form, you're going to defer to metric. Metric is going to control regardless of whatever your invoices say. Why is that an issue? Well, mostly because metric uses, not surprisingly, the metric system. The Department of Taxation's statutory charge is to tax cannabis using the imperial system in pounds. So everybody knows that approximately 453 grams in a pound, but it's not exact. And so there's some breakage. And the breakage is usually rounded up rather than rounded down. So it doesn't seem like a lot unless you have volume sales. And if you do have volume sales, then by using metric rather than using pounds, you're paying a higher price based on the weight of the cannabis in the joints or the pre-rolls than you would through the use of simply weighing it and designating the tax liability is based on what's in your actual invoices, and your actual invoices being in pounds. So again, it's kind of in the weeds in terms of the esoteric, and no pun intended, the esoteric nature of this discussion. But this is another instance of the Department of Taxation imposing a standard of general applicability without going through a formal regulation adopting process of saying we do a notice of intent to use to adopt a regulation. Here's a draft of the regulation. Here's the opportunity to comment and have your comments heard regarding that draft. Here's the draft being reviewed by the Legislative Counsel Bureau and either approved or revised, depending on the LCB's interpretation of the law. And here's the final form. None of that has happened with regard to the department's standards of general applicability regarding pre-AB 430 audits, post-AB 430 audits, the use of pre-rolls, and similar instances. So this issue is currently being challenged. There's an issue has been fully heard through an administrative hearing in which testimony was taken by both the taxpayer and the Department of Taxation. It's been fully briefed and submitted to the administrative law judge, and we're awaiting a decision on that. And in that case, the administrative law judge has been specifically asked to rule on whether the department's use of this standard in an audit without announcing it to the public and to taxpayers as adoption of a formal regulation constitutes an improper adoption of a regulation, a standard of general applicability, without doing it with adherence to the Administrative Procedure Act. The Administrative Procedure Act in NRS 233B 110, subsection 1, specifically provides that a taxpayer or an affected party can ask a court to make a declaratory ruling whether or not that standard of general applicability is properly adopted under the APA, which is valid, is the terminology the Administrative Procedure Act uses. But in order to make that determination, for the court to issue a declaratory ruling, the affected party, in this case the taxpayer, has to specifically ask the Department of Taxation to rule on the validity of that standard of general applicability. So in that particular case, at every instance, the taxpayer has requested the Department of Taxation to rule on the standard of general applicability they have adopted with regard to the use of METRC in doing audits, and specifically the use of METRC over the actual records of the taxpayer. Their decision to adopt that standard general applicability and impose it on the taxpayer in a way that is the equivalent of adoption of a regulation without having gone through the procedure is one of the issues the administrative law judge has been requested to act upon. Now, if the administrative law judge rules in favor of the taxpayer, then it could have ripples to the industry in that for other audits that the department conducts, they would presumably be required to use the taxpayer's records rather than using METRC rather than the taxpayer's records. On the other hand, if the administrative law judge rules that that's not a regulation that's required to be adopted pursuant to the Administrative Procedure Act, then the taxpayer has the ability to have that determination reviewed by a court. So this is kind of an interesting case, not specifically because of the esoteric issue there was METRC rather than business records, but can the Department of Taxation simply adopt standards of general applicability that they apply to all taxpayers, such as this is how we do an audit, this is the records we use, these are the records we don't. That's sort of a decision. Can they do that without adopting a regulation, or do they have the legislative power or the power to interpret legislation and to interpret it in a way that is standardized, such as their interpretation of the statutes that they articulate in their forms, their WMT forms and their WMT form instructions? Can they do that without adopting regulations, or can they simply do they simply have the discretion to continue to do what they've been doing all along, which is sort of create things by fiat? No statute gave them the ability prior to AB 430 to use FMV, yet they created FMV as a fiction. They created a data set. They created a curated data set without any kind of regulation as to how they would go about doing that. And instead, they just announced to the industry, this is how we're going to tax this, and this is the form you use, and this is how it's done. So it could have some far-reaching effects, that pending case. Apparently, the lesson that the legislature attempted to teach the Department of Taxation by the adoption of AB 430 wasn't entirely learned. It was partially learned, but they're still doing things by fiat. And we'll see if that continues once the decision comes down in this case. So why this is important is because there are significant downsides to paying less taxes or paying taxes late, but paying less than the Department of Taxation determines that you do owe. This is a chart taken from the back of the most current WMT form. That would be the one on the left on the slide. We're comparing the 2019 form and the 2025 form. And you see that, if you're 10 days late, it's 2% penalty, 11 to 15, 4%. And, the math is fairly simple there. Once you get past 31 days, you start incurring, and this table is adopted pursuant to a regulation that the Department of Taxation actually went to the trouble of doing a notice of intent, circulated a draft, took public comments, formally reviewed by the LCB, and then codified as NAC 360-395. So if it has an NAC designation, it means the department has actually gone through the trouble of doing a regulation procedure. And in this instance, they actually did that. If you exceed 31 days, then the statutory interest kicks in and other bad things happen. If you ultimately do not pay and you don't have an administrative proceeding such as challenging an audit, a petition for redetermination of an audit, that sort of thing, then you could be determined to have failed to comply with Chapter 372, which is the excise tax, and Chapter 372A of the Nevada Administrative Code, the NACs. And that could actually affect your ability to be licensed. It's hard to contemplate how you would be delinquent in payment of taxes for initial licensure, unless you were acquiring a license and you already had a license for which you were delinquent. But certainly would raise its head if there's a transfer of interest and the transferor is delinquent in their taxes. I've seen instances where the TOI is conditioned upon the taxpayer becoming current in all delinquent WMT taxes. And it would certainly be an issue for the renewal of a license, which happens annually. If someone is delinquent and seriously delinquent in payment of taxes, this statute would, this regulation presumably would give the CCB the ability to deny the renewal of a license. In other words, suspend a license until those taxes were paid. So that brings up a related issue. The NCCRs were for the most part, adopted by the CCB prior to the 2023 legislative session. In 2023, the legislature specifically repealed the CCB's exemption from the Administrative Procedure Act and indicated to the CCB that any regulations it adopted would have to be adopted pursuant to the Administrative Procedure Act. And if you were at yesterday's meeting of the CCB, you would see that they are greatly confused by exactly how they do that. They know they have a obligation to notice of intent. They've done that. They have an obligation to circulate draft regulations for comment, and then they circulate. Once that has happened, they have to provide those draft regulations to the LCB for review. Some people take the position that the NCCRs cannot exist apart from the Nevada Administrative Code, that the Administrative Procedure Act makes it very clear that the role of the Legislative Counsel Bureau is to review proposed regulations of, in this instance, the CCB, and if appropriate, approve those, revise those, and then codify those as part of the Nevada Administrative Code, the NAC. Because of that, it is arguable that the CCB does not have legal authority to adopt regulations which they codify as the NCCRs. That instead, if they want the NCCRs to exist or the regulations they've adopted to exist, they need to go through the formal process of being codified into the NACs. They have not done that in the current round of regulatory amendments that they're doing. They've indicated no intent that their proposed regulations are going to be codified as NACs. In fact, they've noticed them as amendments of the NCCRs. So that's kind of an esoteric legal point, but it is from my perspective, very important because the Administrative Procedure Act is the intended vehicle by which all administrative agencies adopt regulations, and it's the intended vehicle for the public if they want to find out exactly what a regulation adopted by an agency of the state of Nevada has been codified as. They go to the NACs rather than each individual agency having its own discrete set of regulations. So there is some legal dispute as to that point, but I'm not here to give equal sides. I'm here to share my opinion on exactly how that should come down. So at this point, you've got sort of an earful of my perspective on the Department of Taxation and exactly how they really implement the WMT through fiat and through sort of one-sided, this is how we interpret it, this is what it's going to be, rather than going through the administrative regulation process anytime they want to adopt a standard of general applicability. And you've seen it in the context of the WMT for vertical transactions, WMT for arm's length transactions, the use of fair market value that is promulgated through a fictitious finding by the Department of Taxation, the announcement of their interpretation of statute and compacts with Native American tribes, and their internal announcement as to how they're going to use metric data as opposed to the actual records of the taxpayer in doing audits. So those select instances, I think, kind of highlight some of the issues I've had with the Department of Taxation, in that they really have not formally adopted regulations. They tend to do it unilaterally. They tend to do it without public input, and they tend to do it simply by announcing this is how we do it, or in the instance of the use of metric and audits, simply by announcing to a particular taxpayer that we've audited your company and found through our application of this new standard, which we haven't announced to the public, but we're applying in every instance, that you have underpaid your taxes. So, and I think that instead they should, if they're going to do that, they need to formally adopt regulations through the formal notice of intent, availability of public comment, and adoption in a public hearing, which they haven't done so far. But I anticipate until they lose a case, such as they did in the Redwood case, or until they get a spanking from the legislature, as they did in the case of AB 430, they're going to continue doing that. So it's incumbent upon the taxpayers that if you have a problem with the way the Department of Taxation is implementing the statute, to make the request under NRS 233B110 subsection 1 that the Department of Taxation rule upon the validity of the standard of general applicability that they just applied to your case. That gives you standing to challenge it in court without making that request, that they rule on the validity of the standard of general applicability, you may not have the ability to challenge that in court. So there's no magic language other than the request that they rule on the validity of their own standard of general applicability that they're using in your instance. And if you do that, you preserve your right to challenge it subsequently in court. At this point, I'm happy to take questions.
You had mentioned NCCR 5.100 sub 1H regarding the application and renewal of licenses. And my understanding is with the passage of SB 41 in 2025, that section would be going away in the regs. And that's sort of what was represented, that now taxation was going to be taking over everything to do with tax enforcement with respect to cannabis licensees. But I've noticed in the most recent version of the proposed regulations, there's no change to that section 5.100.
That is correct. The round that was reviewed yesterday, the CCB took the position that those regulatory changes that they're proposing to the NCCRs are a result of legislation from 2023. That the hearings that are being scheduled for, I believe, the 2nd of December and the 4th of December are for to correct legislative mandated changes from the 2025 session. But I agree with you that I haven't seen anything to amend
It's
that,
not in there.
even though
Yeah,
it's
so
been
that was
built.
supposed to be taken out. So
Yeah.
we'll definitely be pushing for that. It's
Yeah.
interesting what you mentioned about the use of metric data instead of invoices in the early drafts. Because I had written the early drafts of AB 430. In the early drafts, we use the term contract price, which was based on the Colorado's model, which you were specifically referred to the phrase invoice price because that's what Colorado uses. And it was the invoice price charged exclusive of any tax that was included in the written invoice price. And that language, that was a deleted late by a Senate Revenue Committee just because they believed the way that it was drafted by LCB caused some confusion whether or not it was intended to change the definition of sales price. But really using that term invoice price would have made it so clear that the business records of the business were the ones that were supposed to be used,
Yeah.
not metric data.
Yeah, it's clear what the legislative intent was, even
Certainly.
when it came out the other end, it didn't have that clarity. But in the case that I was referring to, and I don't want to I want to keep the taxpayer's privacy, but I can refer to it generally. In that case, the auditor who was designated the spokesperson for the Department of Taxation, she specifically said it is our policy to use metric rather than the actual invoices and the actual contracts of the client. And in fact, in that instance, they had 3 years of the audit period was 3 years. They had 3 years of records. That's why the floor of my office are 7,000 pages of invoices. They looked at 1 month in that 3 year period of the records. And for every other month of that 3 year period, they looked exclusively at metric, despite the fact that the actual sales price, because the product had changed. It's kind of fact specific, but in that instance, you initially logged it in as flour. You didn't have the opportunity because of that, was from several years ago. The nature of metric was there were 6 product classifications, and even then, the form used by the Department of Taxation had 9 product classifications. So, if you log something in as flour, you couldn't change it to bud, I think until 2019, or excuse me, 2021. I may be mistaken on those dates, but in any event. So you initially logged it in as flour. It was tested as flour, and it stayed in metric as flour, despite the fact that you're selling it as 3 gram buds, which sell for 50% less than flour. It was still taxed as flour because metric still had it classified as flour, and the FMV, which was already an inflated fictional price, was the maximum classification. So the Department of Taxation is more than happy to say it's still flour and it still has a $1,200 per pound price, even though nothing was at that time was selling for $1,200 a pound. And the market did not consider it to be flour. Popcorn bud was, going for $500 or $600 a pound. So, and that's what the sales price was. And a clear reading of the WMT statute says 15% of whatever the sales price was. And sales price is defined to be whatever the price was in the marketplace by a willing buyer or willing seller. But the statute was vague enough. It said the Department of Taxation will verify fair market value. In other words, you didn't undersell in the marketplace. But fair market value is a range of prices in the marketplace. It is not a specific price to be calculated by the Department of Taxation using a curated data set where they throw out the high and the low. And so you end up with I'm recalling, I can't remember who testified. I think it was Mr. Adler testified that according to his math, it was anywhere from 10 to 20% higher value than the actual values for in the marketplace.
That's what we were seeing at the time, if not,
Yeah,
if not more. Yeah.
yeah.
Well, because the
So
data set was incorrect. I mean, they were using a 6 month period that was 3 months, like it was essentially 9 months behind because it was 3 months, 6 months of data that was 3 months behind the date when it was published. And so
yeah.
AB 430 also helped, tighten up that timeline as well, to be more similar to the way to be more recent in time.
By the way, if I haven't given you credit, I really do give you credit for your work behind AB 430. I think
Yeah.
that solved a lot of problems, and hopefully, the case I'm litigating now with regard to the use of metric, for audits, shouldn't be repeated for post AB 430 audits. But you can see they're still using it. Their instructions clearly say that you use metric data instead of your own data, your own invoices, your own contracts for determining weights.
Yeah, which really shouldn't be the case. I mean, and so if, looking into 2027, perhaps this is something that, we need to clarify the definition of, sales price or not, or change it. We originally not used the definition of sales price and used like Colorado contract price because it was different, right? Like it's not just, it was intended to be different. So,
Well, yeah, if you're using sales and use tax as an analogy, sales and use tax is what did you sell it for? And then it's a percentage of that. If you comp somebody, it is, what is the price if you hadn't comped it, and then you're taxed at that. That's simple. To have a curated data set that is manipulated so it's a higher value and use that data set and that value as the basis. I don't know of any other instance where that's done. I mean, if you transfer real estate, it is, was it an arm's length transaction? In other words, was it fair market value? If it was an arm's length transaction and it sold for, within the range, then it's a percentage of what the sales price was. That's how you calculate, the real estate transfer tax. That's how you calculate use tax. That's how you calculate sales tax. Why an excise tax on cannabis is calculated in a different way, other than the Department of Taxation trying to maximize the amount of revenue they're taking from the industry. In many instances, really hurting the industry. I don't see a policy being served there other than maximizing revenue and ignoring the statute.
that's fair. Well, thank you so much. Thank you for the work that you're doing on behalf of licensees. And like I said, I hope to work with you heading into 2027. We do have a question.
Sure.
The reason they're using metric is because it's the easiest way for DOT to gather the sales data from everyone, for sure. We argued very early on that the sales data that required us to submit was not correct due to user entry error. Oh my gosh, absolutely. We have FOIA requested all of the data that was used to determine the fair market value for, I think we did a period of from 2017 or 2018 up until 2023. And a lot of the incorrect data is filtered out because it's either too low or too high. And so if you fat finger something, like usually they'll catch it, but certainly not all of it.
Yeah. No, I think that the person who posed the question actually hit the nail on the head. The testimony in the case I was referring to, the auditor specifically said, I don't have time to go through 7,000 pages of invoices. I can go to METRC and it aggregates everything for me. And I could do 3 years sitting at my desk looking at a data, online data set. I don't have to thumb through boxes of records and I don't have to get my 10 key out and add things up, using an old-fashioned tape. And I can simply ask the computer to do all the work and I don't have to leave my desk. So it's just far more convenient, even though it's an accurate data set. And my client in that case said, "Why do you use your own records rather than metric?" And his testimony was because metric is inherently inaccurate. The only way to report exactly what was paid for that transaction is to use my actual sales records. So my tax returns reflect exactly what the product sold for. Metric does not. If I could add one more thing. I
Of
went to
course.
a Metric conference where I bumped into the president of Metric, Mr. Williams, and I asked him a question about this. I said, "Here's what the Department of Taxation is doing with your software, with your service. What do you think of this?" He said it's not designed to be an accounting uh, product. It is they're evolving, and so maybe someday it will be. But the current iteration of Metric it's great for an inventory control, but it is not accurate enough to be used as a source document as a primary source document in lieu of actual invoices for tax purposes. So there you have it. Metric themselves say we're inherently inaccurate.
You should get that in an affidavit
I
where you
should
can.
get that in.
Thank you so much. Thanks everyone for attending. This was great. And I hope to continuing having conversations about these topics, especially as we look into the new tax permit system that will start rolling out toward the end of next year. Hopefully we can have you back to talk about implementing that.
I'd love to.
Thank you so much. Take care.
Thank you.